Ghanaians are getting to know more after Supreme Court a year ruling on Alban Bagbin and Afenyumakin ebae. Na mama mati asye se Alban Bagbin lawyer aba bonti aba beka se Supreme Court nsemo a womo kan no enye order enye ohye intino Alban Bagbin no opa obedi so opa wondi so. There is another lawyer, your friend Justice Shram Sai. Now, Otaiko radio stations, any TV stations, Eko Kasa about Ghana, especially legal issues. And also, Ede Nintras yet on the Supreme Court ruling, no, Ede Ababe Tuja. Unim said these people are learned people, intino, Omone was a yeti omo ewo in some way eso. Yenge the lawyer wins to walk. Already judgment ni judgment about 109 pages. Already judgment ni we no. Say nintras ye no. E na walk. Now, I say OF Afenyumakin versus the Speaker and AG. I say advisory opinion, sometimes referred to as declaratory judgment, is an opinion which merely declares the meaning or the position of law without giving any enforcement or executable orders. Into what I say, yebano court any judge emua. Enyama bi wo hwa ye friend no advisory opinion. And enyama bi wo hwa ye friend no declaratory judgment. Into judges no omoma sa declaratory judgment na eye adwentre na wo mo atre. Nanso enye ohye se omo hyew se adwen na wo mo atre no diso. I say, the Constitution does not allow the Supreme Court to give declarations without consequential order or directions. That is why it is said what the Supreme Court doesn't. I say that's why it is said that the Supreme Court doesn't give advisory opinion. More particularly, Article 2.2 provides as follows: the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. I say now let's look at the judgment very critically. It was saying normally no Supreme Court any kwanso mama efutu normally no Supreme Court no eye ohye ene wo se wo mo hye. Nanso case we ya aba no ye hwani ehu ni say Supreme Court ade a wo mo aye no eye efutu anase ye ohye. Also, the plaintiff's relief, A, B, and C, are all declaratory in nature. As I mentioned elsewhere, his reliefs 2 and 3 are speculative and interlocutory in nature. They are incapable of birthing a definite or conclusive enforcement orders. It was also someone can say, Utie Afenyumakin, in some of the cocoa pie or court. The say court enye mano na, your friend reliefs na. Enya ohye ena na wo pese court ehye eye Alban Bagbin. Afenyumakin de wo no hwehwe every court ehho nina no na eye futuo ena wo pe. Wan kwase court enhye Alban Bagbin na Alban Bagbin enye bibi. Also in the judgment, the majority opinions granted reliefs 1A, B, and C. Justice Darko Asare, supported by 3 other justices, granted an additional relief which, though described as an in quote order, is in substance another declaration. This is what his lordship stated: an order declaring the interpretation placed on Article 97(1)(g) and (h) as inconsistent with the true meaning and import of Article 97(1)(g) and (h) of the 1992 Constitution. So, really and truly speaking, the court did not make any consequential, executable, enforceable order. In other words, we each have to decide what to do with the declarations. Now, 2 things. It also will share the court no aka judgment on the abana. And you share Oman share Alban Bagbin. Inti nesisia no se ni aba be ye no. E wo se ye nina no. Ye fa adwentre mienu. Enyama mienu na wo se ye nina no. Ye dwen hu. Enyama mienu no eni. Firstly, The plaintiff and his followers have been saying all week that the speaker must comply. The speaker must comply. It appears they will be disappointed because there is nothing in the judgment requiring the speaker to comply with anything. And I may imagine saying I can make the story way better. I'll bring you that story later. You see, I was shocked, and I have that story on my radar. I want to post the fact that I don't know whether Afenyo Kemo, any attorney general, they knew what was going on because who tien some more kana ade we abane there was say Alban Bagbin odiso e was so odiso no question and crofo be say na se monim say ade na mo ye na ade pa eni kwan say mo ka say Alban Bagbin e was so odiso na ko no anim say was say odiso eni kwan say mo ba beka because Supreme Court akasa yente say Supreme Court ama order da ema afe ye katro bi say order we Supreme Court ama e there was say ye na odiso yente da enti no eno e first thing enti utie asem a lawyer we wo kan de wo si so no say omo a wo mo kan MPP for kan Alban Bagbin also this or Alban Bagbin also this no obisa say order ben na Supreme Court na ma e was say Alban Bagbin no this so order be anywhere was Alban Bagbin this so owe was say secondly and perhaps most importantly it also means that the Supreme Court has now, contrary to long-standing precedent and contrary to the express provision of the Constitution, accepted that it can, declaring the meaning of the law without making enforcement orders. Into the first one, and they say, one, omun to me, Sisiano, Alban Bagbin bibi eni ho obedi so. And a second, no, Sisiano, Supreme Court no aye adie bi a NC da. Say Supreme Court no a etufo. Ana aka asem a yama ni pakone kwan so opa obedi so opa wo ndi so because Supreme Court no enyo mo adwuma no because some ma ohye. Into two things. Into this lawyer, just like Alban Bagbin's lawyer, is also understanding it as ruling na abano enye adie bia eye enforceable and enye adie bia eye order aye katre Alban Bagbin to opa obedi so opa wondi so. This is what the lawyer is saying. It's quite interesting. Let's read comments and see what people are saying. Obi say, counsel, I have a set of slightly tangential questions. One, what happens to the wording of the section the speaker relied to make his observation of MPs having vacated their seats? Since it is in Constitution, does it mean the Supreme Court has effectively amended the Constitution? And someone is also asking quite important questions there. Or say then the EC should petition to disqualify the independent candidate who is now contesting as MPP candidate. Likewise, the other 3 MPs. Per this ruling, meaning they presented fraudulent documents to contest since they are still affiliated to their original parties. Or say I think the 5 JSCs, Justice of the Supreme Court, actually side with Justice Amadou Tanko. That is why they didn't make an order. Deep within, they know that a matter requiring such an order should be dealt with at the High Court level, as argued by Justice Amadou Tanko. True. So, being what someone can say, maybe judges need trim no. Or in part because one of them judge, one of the some me the bremo Justice Amadou Tanko. Or because a case way there, when him say enche or before fofro no a case no a result na ba no it will be reversed. Or see when him say enche the results will be reversed. What you say? Into be someone can say ebia na judges ni na no almost side with our judge no can say the results should be reversed no. Inter no one share ma order. So that enda hosa what you say. And no na obi so eka. Or say I've read through the reasoned judgments, though not a lawyer, but it seemed to me that per the reasoning of the 5 majority that with the issue of the Fomina MP, once he has decided to do business with MPP in the same parliament, his can be asked to vacate his seat. And also, so in simple terms, the speaker is not bonded by the ruling of the Supreme Court to comply. Also, I think Justice Adari wanted to fulfill the Constitution to make orders because his order was not an order. But Doc, what do you think about Justice Tanko's dissenting view, especially his wish to have the majority decision overturned? I say, good morning, Doc. Please, could one place an interpretation on the order declaring by JDA that since the interpretation is inconsistent with the intentions of the said clauses 1G and H, there is either a restrictive or an expansive meaning inherent or an executable order to reverse the act? Or say, in essence, the Supreme Court's decision was made in vacuum. Can they apply a new ruling to something that has happened already? I think the Speaker is exempted, and as such, the Supreme Court only advises a prescribe to other arms of government. So a lot of people, siding with, lawyers, no, and I don't know. But I'm going to your comment box, Nimo.